Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana. Today we are touching a little bit on I'm going to call it the New Companies Act. It's been in existence for more than a year now. And we are looking specifically at the different types of business entities that you get, and the procedure for the formation of some of these entities, some of those that still exist under the New Companies Act. With me in studio, I have Wedaad Ebrahim. Wedaad is a colleague of mine at Edward Nathan Sonnenberg's, and she has experience in commercial litigation and general commercial law. Wedaad, assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to the show.
Wa alaikum salam, and thank you for having me.
Wedaad, let's start off just by looking at each of the different types of the business entities and some of the detail relating to each of them.
Well, Yumna, at present now we have various simplified forms. So we'd have your sole proprietor, who's like your uncle in the shop that has, a store and he runs that where his assets are his assets and there's no separation. So that we'd call the sole proprietor. There's no registration, there's none of that. It's a very informal setup. Then we could have what's called a partnership, where you have two or more people who form a partnership for joint purposes, for profit. In that, again, the assets in the business are not separate. It's liability for both the partners, joint and severally. And what that really means is that if it's a two-man partnership, it means that you're liable for 50% and I'm liable for 50%.
All right. Just to go back to your sole proprietorship, I mean, in that case, the sole proprietor is responsible for everything.
He's responsible for everything.
The full liability.
And usually you'd find a sole proprietor, basically conducting business as Uncle Aesop's trading as, or, that's the type of situation that we'd have. It's very informal, and really his assets and the business are not separate. And then with the partnership, again, it's not a registered association. It's the two parties basically forming a partnership with each other for a joint purpose to generate profit. So what happens is if one of the partners die, the partnership goes along with it. If one of the partners becomes insolvent, the partnership as well suffers, because really the assets and the business that they're conducting is one and the same.
All right. Generally, a partnership should be governed by some sort of partnership agreement to at least make some provisions for what should happen in various instances like those that you've mentioned.
Exactly. In most instances, you would have a partnership agreement that regulates what the split of profit is, what's everyone's contribution to the partnership assets, what the purpose of the partnership is, and what will happen if, somebody dies or if one of the partners become insolvent. So you would have an agreement regulating that relationship.
All right. Then we've got the two big ones, and here's where we start talking about the concept of juristic personality, which we can explain a little later, and that's closed corporations and companies.
Yes. So with closed corporations, before 1 May 2011, we had a situation where there was, like you say, two broad categories of juristic persons, companies, where the assets in the business were separate from the people that were running the business. So, and that was usually under the closed corporations as well as companies. Now, just to elaborate more on what a closed corporation is, it's an association of members. It's similar to a partnership, but it's registered. And there's a maximum amount of members, it's 10, and the assets and the partners as they were are separate. So that is what distinguishes it really, is the concept of registration and that the assets and the business are separate.
All right. So basically, you've explained, in a very simplified form, the issue of juristic personality. And basically that means that the closed corporation, or when we get to companies, the company is almost considered to be a person on its own.
Yes.
And yeah.
That's almost exactly what juristic personality is. So as you and I are individuals, we are liable for our own actions. So that's the concept of juristic personality when we talk about a company or a closed corporation. The company is seen as liable for its own assets. It can own assets in its own name. It can litigate in its own name. It can conduct business in its own name. Whereas, for example, in the sole proprietorship, Uncle Aesop, for example, he is one and the same as the business he conducts. There is no split between his personal assets, so his house and everything, and what he's conducting as a business.
All right. Ideally, when looking at what sort of entity to form, what are the considerations people should be looking at?
Well, I think it goes to the heart of what they want to do. So, for example, if Uncle Esop doesn't want any statute governing how he has to run his business, then the sole proprietorship really is for him. The only risk with that is that his personal assets, as well as what he could consider as the business assets, fit into the same pool. So if he were to go insolvent, or if creditors come after his suppliers come after him, they will come after him in his personal capacity. Whereas if he was registered, that wouldn't happen. They'd go after the company. To explain a bit more about what companies are, and I'm sure we'll get there later, but the Companies Act regulates what the relationship a company can have and what third parties can do and what the relationship is basically run and regulated as. But we'll get there.
All right, we've mentioned basically what a company is. So let's look at what makes a company different from some of or from your non-juristic personalities. There is a difference between control and management of a company and ownership. Ownership, lying with shareholders, and control and management being a completely separate area within the company. How does that work?
So basically, ownership, as we understand it, is in simple terms. I own a car. It's my car. I do with it as I want. I am the owner of that car. I control it. I manage it. Now, in a company, it's a bit different, in that ownership doesn't necessarily mean the owners control the business, especially when we look at in terms of the Companies Act. We look at ownership as the shareholders of the company, so who has shares in the company, who owns those shares, and control, we look at who manages the day-to-day running of the business that the company conducts. And that's usually done by the directors of the company. And the directors, while they may be shareholders, it's not a requirement that they are.
All right, Wedaad, let's leave it at that and go for the break. We can continue talking a little bit more about directors when we come back. Stay with us. After the break, we continue talking about companies. We'll also be touching on closed corporations and their place under the new Companies Act. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about different types of business entities and the new Companies Act. With me in studio to help explain some of these concepts is Wedaad Ebrahim of Edward Nathan Sonnenbergs. Wedaad, we were talking briefly about directors before we went to the break, but let's just take a step back and I want to look a little bit at the Companies Act. It came into effect on the 1st of May 2011, and it's changed some things with regards to the different types of entities. It recognizes certain types of companies or entities and then has an impact on those entities, some of which we've mentioned already, that existed prior to the Act coming into effect. So what entities does the Act now recognize?
So the Act broadly recognizes two forms, broad categories, be it we have the for-profit companies as well as not-for-profit companies. Now, for-profit companies, this is where you'd find your PTY limiteds, your proprietary limited companies, your private companies, and your public companies. It would fall within that category. And basically, it's companies that the main purpose of which is to generate a profit. Within that category, you'd also have state-owned companies as well as external companies. Now, an example of a state-owned company is, for example, Eskom, or an external company is a foreign company who sets up shop in or has a branch in South Africa. And then your not-for-profit companies are your NGOs or public benefit organizations, where the main purpose is not to generate a profit, but for some ulterior community purpose. So yeah, those are the broad categories.
All right. Now, looking at the entities that existed prior to the 1st of May 2011, before the Act came into effect, what impact does the Act have on those entities?
Okay, so 1 May 2011 was probably like a death knell to most people, and they didn't understand what the consequences of the new Act was going to be on existing businesses, because it prescribes generally different things that may vary the relationships between shareholders and third parties. Now, basically, the relationship, or when we talk about pre-existing companies or companies that were incorporated under the old Act, those companies continue to exist under the new Act. And the new Act provides for transitional arrangements that basically facilitates a movement into the new way of thinking or the new provisions of the Companies Act as it now stands. And it allows a 2-year grace period for companies and persons to get their act in order to comply with the new Act.
All right. What are some of the provisions that have been made in the Companies Act?
Okay, so some of the most prominent features, or the most in fact, is the company constitution. Now, what that means is basically when a company was incorporated under the old Act, you'd have a memorandum and articles of association which governed the affairs of the company, and it was a public document. It was lodged with the registrar of companies, and people would have access to it if they needed to. Now, under the new Act, we have a single document which regulates the relationship. And the reason why this is because, and it's also a public document, but what used to happen is people used to conclude shareholders' agreements that would vary the terms of the Articles of Association. So now we have one document being the Memorandum of Incorporation, and that document has to sit with the Registrar of Companies, and that regulates everything about the company. So that's the main fundamental change. Some of the other things is the purpose of the new Act is really it recognizes that not all companies are the same, and all companies might have different needs. So it tries to create a situation where some provisions certain companies can opt out of, and other provisions they can opt in. For example, before you would have a situation where a private company was required to be audited. Now, and not all companies, some companies were dormant, so they didn't really require any auditing. But now you have a situation where if you meet a certain level of criteria, it's not required of you to have an auditor. So there's certain opt-in provisions and opt-out provisions to the extent that you want to manipulate what's best for your company.
All right. Just to touch very briefly on duties of directors, it has been said that the duties have become considerably more onerous in terms of the new Act. Is that true? I mean, what are the basic duties on directors?
Well, I think it's a bit of a myth to say it's become more onerous. What we used to have is common law duties of a director, and these are broadly the duty of good faith, and basically that means that when a director is acting as a director, he needs to act in the best interests of the company. And, now what the new Act does is it codifies what was previously in the common law. And to that extent, it tries to create more accountability for directors. And the one thing that it does do is it extends also to what we call company officers. And what that means is sometimes, or in many cases, you have like a general manager who may not be a director but continues and participates in the running of the business but is not accountable as a director. So what the Act tries to do is it brings those people who are involved and informed and making decisions about the company within that net of responsibility so that they too, are responsible for their actions in relation to the company.
All right. Wedaad, in your opinion, when a person's considering what type of company or what type of entity should be formed, should they be consulting with an attorney or, somebody who specializes in at least assessing what their position is and what their needs are, or is it a decision, that can be made if you just assess the Act yourself?
I think sometimes the wording of the Act can be a bit daunting on anyone, but to the extent that you can make that decision, whether or not to be incorporated or not, I think you can make that decision on your own. But when you decide to register a company or to deciding which business entity is for you, it's probably best to get legal advice, because sometimes what you think is the consequence of a particular entity is not really there. So for example, if you form a personal liability company, what that means is you're exactly like Uncle Esop, who's a sole proprietor. You are joint and severally liable with the company. But if you form a PTY Limited, it's a separate legal personality. So it's probably best to take advice.
All right. Let's look at the situation where now you've gone through the process of deciding what entity it is you want to form. how do you go about registering or, forming that entity, that company?
Okay. Well, right now, registration of a company is all regulated by the Companies Intellectual Property Commission, previously CIPRO, so people might be more familiar with the name CIPRO, and they sit in Pretoria, and effectively all registration of companies lies with that body. Now, CIPRO has a very interactive website, and if you can get a lot of information using the website, but in order to register a company, the first step is always going to be reservation of your name. So, and that might seem like a simple process, but there is a little bit, more nitty-gritty to it. There's a process that needs to be followed. So you need to fill in a form, the reservation of name form, setting out at least 3 options of what possible names you'd like. So, for example, if we say Yumna, Bhana, Pty Limited, for example, then maybe that name's taken. So you'd go to the second option, Bhana, Pty Limited, or your third option, depending on what's available. So you give what we call them is SIPC or SIPIC. You'll hear all of these acronyms for them. But generally, if you give them 3 options, it gives them a chance to see, 1, if the name is taken, and 2, if not, then they'll allot you with your first preference. There is a filing fee. I think it's about 75 Rand for manual, and
I think it's 50 Rand.
I think it's 50 Rand for electronic submission. The website does make it very easy for you to submit these applications online. The only proviso is that you need to register as a customer with SIPC, which is free of charge.
Okay. Let's leave it there and go for the break, and we can continue looking at the steps for the registration of a company. Well, you've heard what I've said. After the break, we'll look at the remaining steps for formation of a company. We'll also touch a little bit on the position of close corporations. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about business entities and the New Companies Act. Just prior to the break, we started going through the process of the formation of a company, and we'd gone through step 1. So let's take it from there. Step 2 is the actual registering of the company.
So there we'd have a situation where now you've gotten the name that you want. So Yumna Bhana Pty Limited has been approved by SIPC, and you have now got the go-ahead to register your business. What do you need? You need to file 2 forms, essentially. It's the Notice of Incorporation as well as a Memorandum of Incorporation. I will remember that name from when we were speaking earlier about the constitutional documents of the company. Now, the Act provides for standard, form Memorandum of Incorporations, and if you're using that as your base document, then the filing fee is less. If you're not, if you have a special, remember we were speaking about how there's opt-in and opt-out provisions. So if you have a unique form MOI, obviously SIPC will need some time to go through it. So it's a bit more expensive. I think it's about 475 Rand for that option. But the process is the same. As long as you file the Notice of Incorporation together with your Memorandum of Incorporation and you lodge it with SIPC, I'm not too sure what their turnaround time is these days, but because there was some teething problems, let's say between a month and 4 to 6 weeks, then you should get word from them regarding the registration.
All right, I'm just curious. So SIPC actually goes through each MLI and ensures that it's in compliance with the Act?
Well, nobody's been able to answer that question for me yet, Yumna. I'm not going to lie. I know previously under the old Act, that's exactly what they did. They used to make sure that every single, memorandum of, I call it Memorandum of Incorporation now as one document, but they used to make sure that the constitutional documents was in compliance with the Act, and they used to red flag any items that was problematic. I'm not too sure what the process is now, but I think it's a very similar procedure.
All right. Let's look now at closed corporations. There's been a lot of confusion about what the status of closed corporations are under the new Act. So prior to the Act coming into effect, there was a Closed Corporations Act. Mm-hmm. Is that still effective? Does that still apply, or what is the position of closed corporations?
Well, in short, the Closed Corporations Act does still exist. Secondly, pre-existing closed corporations will still exist under the new Act. What the new Act does, however, provide is that no new closed corporations will be registered by SIPC post 1 May 2011. So that means if you are a closed corporation, an existing one, that's fine. You can't, however, decide that you now want to register a new closed corporation under the new Act. Old existing closed corporations exist very happily under the old Closed Corporations Act.
All right. So it's just a rumor then that closed corporations have to be phased out, and you have to, transfer or change your type of entity from a closed corporation to some sort of company.
Yes, that is a rumor. What the Act does permit, though, it does contemplate a conversion process. So for closed corporations that do want to convert into a company or PTY Limited under the new Act, the Act allows for a 3-year, let's call it a grace period, within which you won't have to pay anything to convert your closed corporation into a PTY Limited or a company under the new Act. The process for that, however, requires that as a first step, the closed corporation can't be in any insolvent, distressful situations. It can't be insolvent. It can't be in business rescue proceedings. The second step is that the members of the closed corporation have to resolve that, they make the decision, or at least 75% of members need to make the decision to convert the company. And then also you need a statement from someone. Give me 1 second.
I don't have it on mine.
Basically, so what the new Act does is it provides for...
Sorry. Are you guys running? Okay.
So the new Act provides for a procedure in terms of which closed corporations can, for free, convert into a PTY Limited or a company under the new Act. And what you need to do there is you need to file a notice of conversion together with an MOI or a Memorandum of Incorporation. And then you also have to provide copies of the resolution of the members of the CC, at least 75%, resolving that they want to convert the CC into a PTY Limited. Together with that, there's also additional documents such as all of the ID documents of the members, information regarding who the incorporators of the company will be. But other than that, the process is free, at least for 3 years after the effective date. So 3 years from 1 May 2011, you can convert your CC into a PTY Limited at no charge.
Wedaad, that concludes the processes for the registration of a company, and then also the procedure to convert the closed corporation into a company. Let's just look a little bit at, and as our last issue, directors. What are the requirements for a director to be appointed? Who would qualify to be a director?
Well, the Act prescribes certain minimum, let's call it criteria. And it says what kind of persons are allowed to be directors of a company. Just to briefly run through some of them for you, is that the person can't be an insolvent, the person can't have been, convicted of a criminal offense. There's also, if your Memorandum of Incorporation sets out further criteria, you can limit it to profession, for example, if you want as well. But basically, if you are considered to be one of the disqualified people, you're not permitted to be a director and your appointment is void. Now, when we talk about the nationality requirements and that kind of thing, I can confirm that there are no restrictions on nationality. So your directors don't necessarily have to be South African citizens, but it's common practice to at least have one director that is, just to sign off on documents to make sure everything's fine this side of the world.
All right. And any other office bearers that are important in terms of the Act?
Well, for PTY Limited, usually we'd say that, and it's not a requirement, but we'd say that a company secretary is important. Now, the designation of a company secretary, why it's important is because in terms of the Act, that is the person that needs to make sure that you comply with all your obligations as a company, not only in terms of the Companies Act, but in terms of other legislation as well. So the company secretary is a pretty important function. And then lastly, in terms of the Income Tax Act as well, you'd have what's called a public officer. And now that's a required appointment for income tax purposes. So as soon as a company is incorporated, within a month thereafter, you are required, in terms of the Income Tax Act, to appoint a public officer. And that person's job is really just to be responsible for all income tax related queries.
Thank you, Wedaad. It's been an absolute pleasure having you to explain the starting principles of the Companies Act to us.
Thank you so much.
Thank you for listening. I don't know what I was going to say, so I won't say anything.
I would have cut you as it is.
Yeah, because I went, don't tell me, Pervez. Because no, I had something specific I want.
Just check the time code. What was the time code there? Okay. And
well, there we have it. A brief explanation of the different types of business entities that existed and that still exist, or that have now come into existence in terms of the New Companies Act, and a little bit of an explanation into how the New Companies Act has affected the status quo. Don't forget to email me on legalese@itvnetworks.tv and follow me on Twitter. Please send me your suggestions for topics and your comments on today's show. And remember to stay tuned for next week's episode. Assalamu alaikum wa rahmatullahi wa barakatuh.